extent required.
The Honourable Chris Finlayson.
Yeah, on a day when we should all be rejoicing, what a negative and mealy-mouthed contribution from Carmel Sepuloni. I was expecting much better from her than nothing more than pettifogging criticisms of what is, in the words of David Clark, the most significant rewrite in 50 years. And it is timely that we have this rewrite because the Social Security Act 1964 is a shambles. It's unintelligible. It requires legions of lawyers and MSD, like soothsayers, to go through the legislation and its amendments to try and discern its meaning. The public don't know what it means in a critically important area of law, and that is why we're doing it. So it is something that has been commended to this House by retired Supreme Court judges, by the Law Commission, by academics on many occasions, and it's a tribute to this excellent minister and her wonderful team of lawyers at MSD and the great team at PCO that we have reached this stage. So instead of mindless criticism from Carmel Sepuloni, we in this House should be rejoicing, and we should be supporting the rewrite of legislation across all fields, which is out of date, because it's the fundamental right of the citizen to know what his or her obligations or rights are in legislation. We can do revisions under the Legislation Act of 2012, and I'll shortly be bringing to the House a very interesting revision, but this is not a simple revision. This is, if you like, a revision plus. There are a couple of matters that were required to be included to bring the legislation up to date, and this bill is an example of the kind of work this House should be undertaking. And lest anyone think that the rewriting of legislation is some kind of cold, arid exercise, it actually goes to the heart of a parliamentary democracy. A senior English judge once analysed the rule of law in 8 sub-rules, and one of his sub-rules was that the law must be accessible and, so far as possible, intelligible, clear and predictable. And a very wise person, a person who served this House for many, many years, the former Chief Parliamentary Counsel, the late George Tanner QC, once said, "A state in which people cannot plainly understand the laws might as well be a lawless state." So here we are. It's a great day for Parliament that we're dealing with this legislation to introduce what could be called a plain English approach to complex and often convoluted legislation. Too much of our legislation is wordy, is hard to understand. Mind you, it's going to take a lot to beat this real shocker from the United Kingdom contained in the Banking Act 1979 appeals procedure, England and Wales Regulations 1979, which says, quote, "Any reference in these regulations to a regulation is a reference to a regulation contained in these regulations." I mean, that is exactly the sort of rubbish that all too often is put in the statute book, and it means nothing. And therefore one has to employ lawyers to interpret that kind of garbage. And while I'm very much in favour of lawyers getting a fair share of the fees, I think that that kind of reference is simply nonsense. So my congratulations go to Mrs Tully, an outstanding Minister of Social Development, who has done such a wonderful job at pushing this legislation reform through. There are no votes in it, but it's extremely important to maintain the structure of our legislation and, if necessary, undertake a Leviathan rewrite. And Mrs Tully has done what many, many ministers in the past have failed to do. She has grasped the nettle, and I am so very, very proud of her. The second matter I just want to refer to is my Section 7, because Mrs Tully did say, and it was a fair enough point, the provisions relating to blind people, the totally blind, have been included in the legislation from time immemorial, but when we did the rewrite, it was an opportunity to go through the legislation, even though it is a rewrite and say, well, let's just kick the tyres in Bill of Rights terms to see that nothing breaches the Bill of Rights. And there was this issue that arose, and I hope the Select Committee will take a look at it and perhaps give the House an opinion. Clause 33, which deals with the supported living payment on a ground of restricted work capacity or total blindness, and sets out the requirements. And I also refer honourable members to Schedule 4 on the rate of benefits, and particularly to Part 3, which deals with the supported living payment. Part 3, Clause 1E, sets out the payments to a beneficiary, but says, in computing the income of any beneficiary receiving a supported living payment under Section 33, I should say, for the purpose of this schedule, MSD must disregard that part of the beneficiary's income not exceeding $20 a week earned by the beneficiary's own efforts, and secondly, disregard all of the income of a totally blind beneficiary earned by the beneficiary's own efforts. So on the face of it, there would appear to be an issue which engages the Bill of Rights substantively. It may be understandable, but in Bill of Rights terms, there does appear to be a discrimination between various classes of groups suffering from a disability. Individuals who are totally blind are eligible for certain entitlements that people with other disabilities are not entitled to. And so that is why I reached the conclusion that the distinction materially disadvantages people with disabilities other than total blindness. So that's the reason why the Section 7 was produced, although it was produced in the knowledge that the provisions have been in the social security legislation for quite some time. So I hope that there will be other examples of rewrites in the months and years to come. Both parties have done it in government. The Labor government was Mrs. King, when she was Minister of Justice, kicked off the reform of the Limitation Act. And that was a piece of legislation that was so lousy that the Court of Appeal was saying, we can't do anything with this legislation, it's beyond repair so far as the judges are concerned, there needs to be work done. And that is why Mrs. King, when she was Minister of Justice, got on with reforming it and got the Law Commission to look at it, and the result is we have a Limitation Act that is now fit for purpose. So these things do matter. Keeping our legislation up to date should not be the cause of that biting negativism type speech that we heard from Carmel Sepuloni. We as parliamentarians should be very pleased this sort of thing has happened. As I said, law commissioners have told us to do it, judges have told us to do it, and now we're actually doing it. The first rewrite of social security legislation in 50 years, and I have no doubt at all, given the gruesome smile by the Green MP sitting down the back, that we're about to endure another negative speech on the subject. But I say to her, as I say to all the House, in the immortal words of Mrs. Thatcher, rejoice, rejoice. This is indeed a great day.
We have become grandmothers.